Do you know your rights when you are arraigned before the court or brought before the court? Hello, distinguished friends. I'm Legalized Mimi. Welcome back to my YouTube channel. If this is your first time here, please kindly subscribe to my YouTube channel, like, comment, and repost. This page is quite informative. We talk about the law, the reasons you need a lawyer in your life, and general issues of life. Okay, so today we'll be talking about rights. When you're charged to court, when you're brought before the court, what are your rights? Do you know your rights? Okay, so we'll be referring to the Constitution of the Federal Republic of Nigeria as amended. So, and whenever I mention the section, just know that I'm referring to the Constitution of the Federal Republic of Nigeria. So, let's get to it. You have the right to fair hearing. Whenever a person is charged with a criminal offense, he shall, unless the charge is withdrawn, be entitled to a fair trial in public within a reasonable time by a court or a tribunal. So we're going to be using two Latin maxims to explain this. Please relax. I know now you've heard Latin maxims, you'll be like, what? Okay, so I'll explain it. We have all the alterem patem, so which means that each party should be given an opportunity to be heard. So the prosecution in a criminal trial, the prosecution will be heard, the defendant will be heard. In a civil trial, the claimant will be heard and the defendant will be heard. So every party in that case should be heard. That's your right to fair hearing. Then we have the next Latin maxim is nemo judice in causa sua, which means a person shouldn't be a judge in his own case. So the judge should not be biased, and when a commoner looks at what the judge has done, will he have the impression that the judge was biased? The judge must not be interested in any of the parties or the subject matter of the case or the outcome of the case. So the judge should be what? A neutral party. This guarantees your right to fair hearing. Then we have the right to trial in public. This is provided for in section 134 of the Constitution of the Federal Republic of Nigeria. So publicity of trial means trial in a courtroom properly so designated or any place where the public has unimpeded access. The general rule is that the courtroom is open to the whole world. So the courtroom is open to the whole world. Anybody can just go to court to see how the judges and lawyers dispense justice. You have the right to just walk into a court to witness the court proceedings. However, as I tell you, there are exceptions to general rules in law. So certain exceptions to this where the public will not or might not have access to the courtroom in cases of sexual offenses, offenses under the Prevention of Terrorism Act, offenses relating to economic and financial crimes, trafficking in persons and related offenses, in the interest of justice, of defense, public safety, public morality, public order, welfare of persons who have not attained the age of maturity, that's children, for the protection of private lives and properties of parties. So in these cases, you get the public may not have access to the courtroom. Then we have the right to speedy trial. As I mentioned earlier, when a person is charged with a criminal offense, he shall, unless the charge is withdrawn, be entitled to a fair trial in public within a reasonable time by a court or tribunal. So an accused person is entitled to a fair trial within a reasonable time. The accused is entitled to know his fate as soon as possible so that the curtailing of his liberty and the period of the trial can be minimized. So you're entitled to a fair trial within a reasonable time. So a reasonable time depends on the circumstance of the case, you know, the nature of the case, the number of witnesses that will be called, and the the judges probably being transferred and all of that, the number of exhibits that will be tendered. So a lot of things determine what amounts to a speedy trial. But you know that reasonable, when you say reasonable means moderate, tolerable, not excessive. Okay, then we have presumption of innocence, section 36 sub 5. So every person charged with a criminal offenses will be presumed innocent until proven guilty. So until your guilt has been proved by the court, you are presumed to be innocent. So the presumption of, until the guilt of an accused is established, he or she is presumed to be innocent. So you are presumed to be innocent until your guilt has been established by the court. So that's your right. Then you have the right to information of crime committed, section 36 sub 6a of the Constitution. The accused has the right to be informed properly promptly, that is quickly, and in the language he understands, and in detail the nature of the offense against him. Do you understand? So this is the crux, this is the foundation of arraignment. You have to read the charge to the accused person and explain to him in the language he understands. You understand the nature of the offense against him, the offense he has been brought to answer, and then he will plead to such charge. And you have the right to adequate time and facilities to prepare for your defense. Section 36 sub 6b of the Constitution. Every person charged with a criminal offense shall be entitled to adequate time and facilities to prepare for his defense. So you'll be given time to, of course, discuss with your lawyer, to get your witness, to procure the attendance of your witnesses and all of that. So the court will give you reasonable adjournments for that. But if it is unreasonable, I don't think the court won't give you such adjournment. So it is for the court to decide what is reasonable adjournment in the circumstance of the case. You have the right to counsel. Section 36 sub 60 of the Constitution. You can defend yourself. You also have the right to engage a lawyer of your choice. So please, I keep telling you, the importance of lawyers cannot be overemphasized. Engage a lawyer today, because you need them to handle virtually all aspects of your life. Is it marriage? Is it your finances? You understand? Your cases, your affairs, your businesses. So please, you need a lawyer today, so engage one. I always tell people, yes, you have the right to defend yourself, but it is better and proper to engage someone who is in the field, who knows all he or she has to know about that profession. Then you have the right to interpret, section 36 sub 6e of the Constitution. So when you're charged with a criminal offense, you have the right to be informed in the language you understand, at no cost to you, of the offense that you've been brought to answer. Okay, so you have, if you speak Hausa language, and the language of the court is English, so, and then you only speak and understand Hausa, and you're brought to the court, the court has to provide an interpreter for you to interpret the charges to you in Hausa. And then if you say something in Hausa, and you know the language of the court is English, the judge or the might not understand your language. So someone will also have to, an interpreter, not just someone, an interpreter would have to interpret what you've said from Hausa to English, so that the court would understand too. So you have the right to an interpreter at no cost to you. Then you have the right to be tried only for an offense known to law. Section 36 sub 12 of the Constitution. A person shall not be convicted of a criminal offense unless the offense is defined, and the penalty therefore is prescribed in a written law. So you cannot be tried for an offense that is not prescribed, that is not defined. You look through all the laws, and such act has not been defined as an offense. You can't be tried for such. You have the right to be tried only once for one offense. You understand? The right to be tried only once for one offense. So section 36 of 9 of the Constitution, the right against double jeopardy, and we have two Latin maxims to define that: autro for convict and autro for acquit. So an autro for convict, if you've been convicted of an offense, and then you've been convicted, you've served your sentence, that you cannot be tried again for that particular offense as long as that offense is the same. You've been convicted, you've served your sentence, and then you are now charged again to court for that same offense. No, you have to raise it up as a defense that no, I've been convicted for this offense and I've served my sentence. Then autro for acquit, probably a particular act. You've been brought before the court, you've been charged to court for that particular act, and then you've been acquitted by the court have set you free. You cannot again, you understand, be brought before the court upon such, to answer for such act. So however, there are certain things you have to satisfy to plead this autro for convict or autro for acquit. So the first trial must have been on a criminal charge. The first trial was before a court of competent jurisdiction. The earlier trial relied upon ended either in conviction or on acquittal. So when you satisfy this, then you can plead this defense, autro for convict or autro for acquit. So the right against double jeopardy. You can't serve sentences 2 times for a particular offense. You've served, they brought you before the court for it, and then you were convicted, you served your sentence, and then they want to bring you back again on the same. Oh no, it's not done. So that is why you need lawyers in your life. They educate you about this, inform you about this, and guide you. Well, you have the right to silence, section 36 sub 11 of the Constitution of Nigeria. Okay, so when you're before the court, you could choose to remain silent. You're not, the court is not, cannot compel you to give evidence, so you can just decide not to say anything. That is your right, section 36 sub 11 of the Constitution of the Federal Republic of Nigeria. Right not to be convicted on a retroactive legislation, section 36 sub 8 of the Constitution. Okay, so let me explain this. Probably, let's say, I don't know what example to use, or let's just say in 2018 an act was not an offense at 2018, and then you did that act, or you made an omission in 2018, and as of 2018 such act omission wasn't an offense, and then let's say 2020 the National Assembly enacts a law, and then such act was now made an offense in 2020. So you cannot then be convicted or brought charged to court for that act you did in 2018, or that omission you made that was not an offense in 2018. They now want to backdate that law to now convict you. No, you can't. They can't do that. So it is your right not to be convicted on a retroactive legislation. As of 2018, it was not an offense, it was not a crime. So you cannot then be charged to court for what you did in 2018 that was not a crime. Then 2020 they enacted a law to make it a crime. No, you can't be charged to court for such. Right to examine witnesses, section 36 of 6D of the Constitution. The accused has a right not only to call and examine his own witnesses, but also to cross-examine the witnesses called by the prosecution. So you call your witness, you examine them, and you re-examine them, and then you also have the right to cross-examine the witnesses of the other party. Okay, you have the right to cross-examine them. You have the right to have all defenses raised and considered. So when you're charged to court for an act, your lawyer, you engage a lawyer, your lawyer has he has the right to bring all the defenses available to you. You understand? The court will consider them. It's your right. Right to have all reasonable doubts resolved in the accused's favor. You know that an accused is presumed innocent until proven guilty. So if there is any doubt in the mind of the court which are considered reasonable, such doubts are resolved in the favor of the accused. That is what this is just saying. Then pardon. So section 36 sub 10. So no person who shows that he has been pardoned for a criminal offense shall be tried again for that offense. So if you've been pardoned before for an offense, you can't be tried again for that offense. So that's provided in section 36 sub 10. So I hope this was quite informative. See you next time. Bye.